continuation of the impeachment trial of the Honorable Chief Justice Renato C. Corona of the Supreme Court is hereby called to order. We shall be led in prayer by Senator Manny Villar. Please sit.
Today is Ash Wednesday, a humbling reminder of our mortality, that from dust we were created, and to dust we shall return. What we do on this earth, we shall account to the great judge and jury. Lord, you have said, administer true justice. Show mercy and compassion to one another. Do not pervert justice. Do not show partiality to the poor or favoritism to the great, but judge your neighbor fairly. Allow us then, O Lord, to sift through the facts with an unflinching eye for truth, in accord with the precepts of justice. Let your servants ferret through the impeachment process by looking where there is wrongdoing and discerning where there is none. Let no man, wealth or malice, stand between his court and his purpose. As elected senator judges, make our institution a bastion of democracy, and let our conduct mirror the spirit of unity rather than divisiveness. Bantayan mo po ang bawat salitang lalabas sa aming bibig, naway hindi ito pagmula ng hindi pagkakaintindihan o pagkakagalit, bagkos ay magdulot ito ng liwanag sa aming mga kaisipan. Panginoon, ikaw ang pinagmulan ng lahat ng pag-ibig at karunungan. Tanggapin mo po ang panalangin ito bilang alay sa iyo at sa bayan. Ikaw ang aming lakas, at sa pamamagitan mo, kami ay naglilingkod sa bayan. Inihiling po namin ito sa banal at dakilang pangalan ni Jesus. Amen.
Amen. The Secretary will now please call the roll of members.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, the Senate President.
There are 20 senator judges present. The presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
I move that we dispense with the reading of the February 21, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Any objection? There being none, the February 21, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. Secretary will now please call the case.
Case number 00222011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances. Majority Floor Leader.
Yes, for the prosecution, Mr. President.
Good afternoon, Mr. President, Your Honor. For the prosecution panel of the House of Representatives, same appearances.
Noted. The defense.
For the defense, Your Honor, the same appearance.
Noted. Majority Floor Leader.
Mr. President, before the business for the day, Senator Miriam Defensor Santiago would like to be recognized.
The lady senator from Iloilo is recognized.
I I beg the indulgence of our colleagues in making this manifestation. Our Constitution provides under Article 3, which is entitled the Bill of Rights, Section 1, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Section 1 is only one sentence. It consists of two parts, what lawyers call the Due Process Clause, and number 2, what lawyers call the Equal Protection Clause. And yet, Section 1 is so powerful that even if you deleted the entire Bill of Rights and remained only with Section 1, every single Filipino citizen would still be entitled to the entire panoply of human rights enshrined in our Constitution. Ganon katindi ang bigat ng Equal Protection Clause at ng Due Process Clause. Ngayon, the business for the day is the Due Process Clause. Because yesterday, prosecution wanted to present a PAL officer, and presiding officer ruled that because bribery is not alleged under Article 3, then prosecution cannot present that PAL officer. I support that ruling. In fact, I insist on it because of the Due Process Clause of our Constitution. The Due Process Clause is so important that, as I said, in the view of certain constitutional experts, with tripartite democracies like ours all over the world, tanggalin mo ng buong saligang batas, iwan mo lang ang due process at ang equal protection clauses, meron ka ng proteksyon ng buong saligang batas para sa karapatan pagtao. That is how important due process is. Ngayon, hindi lamang iyon ang probisyon ng ating konstitusyon, kung hindi sa Constitution mismo, hindi sa rules of court lang, sa Constitution. The Constitution, Article 3, which is also the Bill of Rights, going down the rights, Section 14, Paragraph 2 provides, in all criminal prosecutions, the accused shall be informed of the nature and cause of the accusation against him. That is due process. That is how our Constitution defines what due process is. You must inform the accused, any accused person, in a criminal proceeding or in a semi-criminal proceeding such as ours, of the nature and cause of the accusation against him. And, accordingly, the rules of court provides. Section 1, Rule 115, Rights of the Accused. Section 1, in all criminal prosecutions, the accused shall be entitled to the following rights, letter B, to be informed of the nature and cause of the accusation against him. So the rules of court is nothing but a reflection of an actual constitutional duty imposed explicitly by the Constitution. That's why we cannot admit the testimony or any other evidence of an officer, of any person, of any witness, concerning an allegation which has not been included in the complaint or information, or as in this case, which has not been included in the articles of impeachment. Merong mga bilitero dyan, seeking a false note, na magsasabi, bakit anong diferensya? Testigo lang naman yan, isingit mo na lang doon. Hindi pwede yan. Because that's violative of the Due Process Clause of the Constitution. This is more or less, virtually, the same situation during the President Estrada trial, when I voted against opening the second envelope unless the prosecution first amended their information. My basis was due process of law. Ganon na rin yan ngayon. Meron tayong testigo dito. Ngayon doon sa President Estrada trial, naalala nyo? Opening of the second envelope, binilang kami isa-isa. Tapos nagalit ang publiko, well, at least part of the public, against me dahil nagboto akong huwag niyong buksan yan. Actually, yung boto ko, pwedeng buksan, pero amendahin o baguhin mo muna ang complaint or information para mabigyan ng due process clause ang akusado so that he can be informed of the nature and cause of the accusation against him. Ngayon, nabuksan, bandang huli, yung second envelope, wala palang laman na incriminatory doon. Kaya, what was all that fury about, that pretended anger at the pretend violation of the constitutional rights of the prosecution at that time? Ngayon, maliwanag sa ating saligang batas at sa ating rules of court na hindi ka dapat magbigay ng ebidensya, testigo man o anumang exhibit mo, kung hindi mo